Good morning. Thank you for joining us today. Today is Wednesday, April 6, 2022, the Lee County Board of County Commissioners zoning hearing. Please rise for the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you for joining us this morning. I will lay down a couple of rules real quick. If you could, if you have a cell phone, if you please turn your cell phone off if you've never been here before. And this is a zoning hearing. And during the zoning hearings in Lee County, we have some administrative code rules we like to follow. So there is we do not allow clapping, cheering, booing of any kind during public comment or any of the comments from staff on either side. This case was already heard by the hearing examiner. That determination was done at that point. This is now before the Board of County Commissioners for final adoption. At that time, like I said before, doing the public comment to give everybody the right to speak without being intimidated. We ask for no clapping, no cheering, anything else. So thank you. Staff, I'd like to present the first case.
Commissioners, good morning. For the record, Anthony Rodriguez, manager of the zoning section in the Department of Community Development. We have 5 cases for you this morning, 2 planned developments and 3 conventional rezonings. First case this morning is Hampton and Suites. I'm going to introduce Sharam Badamchian, who will walk you through that case.
Great, thank you.
Good morning, Commissioners. Sharam Badamchian from Lee County Zoning. This case is a rezone from C2 commercial to CPD, commercial plan development, to allow for a hotel with up to 131 rooms. The property is located to the north of Bell Tower Shops and is in the mixed-use overlay and intensive development area. The hotel will be surrounded by another hotel to the east, and there's another hotel to the south. The area is highly developed with commercial uses. Staff reviewed this and recommended approval, and hearing examiner recommended approval of the case. There were no participants of record.
Thank you.
Thank you.
Is the applicant here wish to address the board?
Good morning. For the record, my name is Ahmad Corey. Thank you so much. Thank you for making it short and sweet. We agree with staff report, agree with the hearing examiner recommendation. Thank you so much.
Great.
Anybody have any question, I'll be here.
Thank you. We'll come back to the board. Any questions at this time?
If I could, Mr. Chairman, yeah, only one question I had just for our development staff. I saw it's in the mixed-use overlay. One of the reasons why we did the mixed-use overlay was so that some of these changes could be made administratively. Why did this one have to come in front of us as opposed to just being administratively approved?
This particular case, Commissioner, exceeds the maximum density in terms of the number of hotel units. Okay. The only way to have that number of hotel units approved was through a planned development rezoning.
Okay.
Otherwise, you're correct. It would have been approvable administratively.
Great. Thanks.
Any other questions? We'll come back to the, we have no participants or records from the neighbors in the area, and we'll come back to the board for a motion.
I'll move approval, Mr. Secretary.
We have a motion, we have a second. Any other discussion? Any objection? No objection, motion carries. Thank you. Next case.
Good morning. For the record, Peter Blackwell with the Lee County Zoning Section. The case I am here for is the first of 3 related cases, the Meadowbrooks Estates Rezone Block 62. Just as a quick overview, these 3 cases to be heard today are part of a larger development. One case relating to these has been heard and approved by this board a few months ago. And the location of the case is obviously in Meadowbrook Estates. Now, this is in Lehigh Acres, thus the endless sea of single-family lots that you see here. This is about 1,500 feet west of Joel Boulevard, and it's north of 7th Street on Glen Avenue. This request is to rezone these two parcels, which is .64 acres, from the single-family residential RS1 to multifamily residential RM8. The hearing examiner has recommended approval of this case, and there were two participants of record at that hearing. And if you have any questions.
Right. Any questions from staff at this time? Being none, would the applicant like to approach the board? Good, thank you. Okay, we'll call the participants of record now. We have Chris Huber. Is Chris here? And after Chris, we have Donald Stein. Good morning.
Morning.
Thank you for coming down.
Thank you for letting me stand up. A year ago, my wife and I bought a house on 7th Street to retire. I guess if we'd have known about the duplexes coming, we might have considered a different area. The streets are too narrow. There's enough development there. In a couple of years, you'd have your 64 single-family households in the neighborhood. And I just don't care to see low-income duplexes where I'm living. And I guess that's my main concern. Thanks for letting me get up.
Thank you. And next speaker is Donald Stein. Welcome back, Donald.
Good morning, gentlemen.
Morning.
As you know, I was probably here yesterday.
Sir.
I guess my biggest problem is I live at 707 Washington Avenue. There are no duplexes in line for my street. But 2 blocks to the west of me, 2 blocks to the east of me, and 3 blocks to the east of me. So I'm basically right in the middle of all the rezoning possible. My biggest concern is comparing it to Southwest Lehigh, which is a heavy density of duplexes. I think you're probably aware of that, and you're probably also aware that it's probably the high crime area in Lehigh Acres. I would really hate to see that expand into our neighborhood. We have a nice, quiet neighborhood, very peaceful the way it is. I'd like it to stay that way. I'd like your support in that. Also, you approved one a couple months ago, I just heard. If you move to not approve this rezoning, could you possibly rescind that motion of 2 months ago and stop all the duplexes in our area? Thank you.
Thank you. Donald is the last speaker on that case. We'll come back to the board for any comments or motion. Any motion or comments, please?
I'll make a motion.
Okay, we have a motion. Motion is to approve the recommendations. Okay. So we have a motion and a second. And gentlemen, thank you for coming here to speak. And I'm sure you've been told this before by staff or not, but under the current circumstances, we cannot legally change a prior zoning case. People have property rights, and including this case here, we have to follow the law. So if there's not any credible, substantial evidence to change what's already been done in the prior case, we have to approve what's recommended by the hearing examiner. Otherwise, the county would be held liable for that. So I understand your concerns. If I was your neighbor, I totally understand, but we have to follow the record of law here. So thank you. We have motion second. Any other discussion? Any objection? No objection. Motion carries. Thank you. Next case.
Again, Peter Blackwell with the zoning section. REZ 2021 11 is a similar case. The applicant is requesting to rezone an area consisting of 12 contiguous platted lots, approximately 3.55 acres, from RS1 single family to RM8 multifamily. As you can see, the location is along 7th Street and along Broadway, running north. The hearing examiner recommendation was for approval, and there were no participants of record for this particular case.
Thank you. Would the applicant wish to address the board on this case? Okay. We'll come back to the board. We'll do participants. Or any questions at this time for staff? I have a question for staff. Do we have a timeline of actual, if this is approved, of construction or anything? There's a lot of changes here in this one street.
Mr. Chair, that might be a better question for the applicant
Okay.
in terms of construction.
The applicant, come forward, please, just for a quick question.
Okay. Yeah,
Good morning, Al Quattrone.
That's right, yeah, thank you.
just, I'm sorry, I misstated. There was actually five people of record on the participants.
Yes.
My mistake.
That's right, no, thanks, good, thank you. Do you have a timeline of actual approval based upon, I know the market's really busy right now, but as you're looking at in the future, is this for 5 years, 10 years, tomorrow? What timeline are you looking at the applicant?
Again, Al Quattrone with Quattrone and Associates. I'm also the property owner of the property. We're looking to ideally start at least 5 duplexes here as soon as we can work through the whole permitting process would be the goal, and then ideally do 10, maybe 10 a year and until we complete it. Totally, once we complete all the zonings around there, I believe there's about 30 lots that ring around the Meadowbrook properties that we have.
Okay, great, thank you.
Quick question, Mr. Chairman, while we got the applicant here. I heard somebody mention the word low income. Are these market rate housing, or are these?
The intent is to be market rate housing. And because we are what I consider in an area different than Southwest Lehigh, that I'm familiar with those areas and the degradation, we would like to do something a little bit nicer and take advantage of it. Just for a little bit of history, so there was 135 lots total in this Meadowbrook Park area that I ended up acquiring. About half of those are being turned into TDUs for the TDR process. There's another 30 or so lots that we're looking at constructing lakes and working with Lampstead to eventually take those lakes over so they can use it for water management. Those will be the lots in the center of the area that are in uplands that don't have roads to them. So most of these duplex lots, or I like to call them twin villas now, are either going to be backing up to a wetland or to a lake. So we just feel like that has a little bit more of amenity than what you'd see down in the other parts of Lehigh. So we are optimistic that we can make it a little bit nicer project.
So follow-up question, if I may, Mr. Chairman. So can you show me on there where you're gonna build that preserve area? Because I think that's important. You're not planning to build on all the lots that you own. Then you're actually going to turn some of them into a preserve.
Yeah, there's when we acquired it, I believe there's 145 lots. Of those 145, we're only building on 30 of them. I think it was about 76 of those are jurisdictional wetlands that we've in the process of vacating the lot lines, easement lines, and roads through those and turn it into a conservation easement. That will also be turned over to Lampstead that they can utilize. Lampstead owns the property north of George Canal as well that they turned into a preserve and water management area. Essentially doing the same thing on the south side of the pond. I don't know, can I draw on here?
Yep.
Yeah, so well, so basically all of this area right here and kind of extends off. Those are the wetland lots, and then we're looking at doing a pond right there so that all these lots that are already on existing roads will be backing up either that wetland or the pond. And then on the west side, which is the next case that Peter will bring up, which is more to the west, again, we're looking at building a lake on the uplands and then have 5 more lots over there that would be developed. So when you look at the end of the day, what could have been platted and approved for 135, we'll have 30 lots, which is 60 units. So there's still a considerable reduction in the total density of homes that could have been in this platted subdivision area.
Thanks for that explanation. Thanks, Mr. Chairman.
Thank you. Any other questions?
And will Lampstead be doing the maintenance on the preservation area?
Yeah, they have agreed to, we had a developer's agreement, they have agreed to go ahead and take on that perpetual maintenance of it once it's turned over to them.
Okay. Thank you very much.
As well as the lakes too. The agreement with them is once the lakes are built per code and certified, they would then look at taking those over as well.
Thank you. Thank you, Al.
Thank you.
We'll call the first participant record. We have Frank Donato. Frank here? Robin East. Oh, Frank is here? Okay. Come on forward. Then after Frank, we have Robin East.
Okay, as we discussed yesterday about this conservation, I just have to bring a point up that on February 24th at the Lambza meeting, this project was rejected. They're not telling you that. And then it went back to the hearing examiner, which we weren't allowed to participate in, and approved to bring it to this point. I think our rights were effective with that. We weren't allowed to speak up. We never knew about the meeting. And I know, Mr. Hammond, you had asked about the design. Could I show you this?
I think so. Am I allowed, is it information that's been presented? Show him real quick first and see what
It's
he's.
not presented at the hearing
Is this
exam. We have
presented
to
at the
routine
hearing
see it.
examiner hearing?
Yes.
Okay.
Okay.
This is basically a layout, the way it's going to be. So you're encapsulating wetlands. And they want to use this as conservation area, but there's no access to it. So how's Lambza going to maintain it? There's no access, unless you use a dune buggy or something, I don't know. But I reiterate about the Executive Order 11990. I reiterate about Section 2B of Executive Order 11514, which states, effects of public health, safety, welfare, including water supply quality, recharge, discharge pollution, and flood and storm hazards. I request that the DEP and South Florida Water Management review this case in its entirety for being valid. That's all I really have to say today.
Okay, thank you, sir. Next speaker is Robin East. And after Robin, we have Deborah Schuman.
Hello, I'm Robin East. I have a couple concerns. My husband and I, for 35 years in New York, ran a business where we pumped septic tanks. My concern is all the septic tanks that will be in that area, just, you know, the overuse, the overflow. Our house is right there. What's that going to do to our well? That bothers me. Another thing that bothers me is that retention pond being so close to those homes. You're talking families and children. That bothers me as a grandmother and a mother. That bothers me as well. So those were basically my concerns, and I really don't want it in my backyard. Like we said, we love our area, and it's very peaceful and quiet, so those were my concerns. Thank you.
Thank you. Deborah Schuman. And after Deborah, Donald Stein.
Good morning. My name is Deborah Schuman. I'm a realtor in Lehigh Acres and a 35-year resident of Lehigh. I live 2 blocks from this project, and the reason I purchased my home is because of the size of the properties there. If you'll notice, many of them are half-acre lots. We actually have an acre, and not within probably many blocks, 10 or so, are there duplexes in that area. So my concern is, from a personal standpoint, I moved there for that reason, to have the bigger property and have single-family homes. From a So just imagine, on the 3.55 acres, there potentially, with half-acre properties, could be 7 homes. But with this project, there will be an additional 41 families living there, which is a huge impact, I think, to the area. From a professional standpoint, as a realtor, as development occurs, and development of single-family homes versus duplexes, there's an impact economically, I think. Duplexes are typically rentals. I don't know that the owner of record is planning to manage those duplexes, which creates a problem from the standpoint of who's going to be living there, who's going to be monitoring it. And so I think from that standpoint, from a professional standpoint, I think it's going to be a huge impact on economically. The developer may win from this, but I'm not sure that the families living there will be winners in that sense, nor the families like Robin and the other families that live in the neighborhood. I just think Lehigh is almost 100 square miles. We probably have 80,000 lots that could potentially be developed into duplex properties. I just think it's not the right place for it. And I don't want to be one of those that says not in my backyard, but unless they're going to be managing them, or unless they're villas or something that's other than a duplex, in my mind, I need to be convinced by them that that's not what's going to occur, and I haven't seen that so far. So thank you for your time. Hope you make the right decision.
Thank you. Donald Stein?
Do you remember what I said before?
Sir.
Thank you.
Next speaker is Mr. Torres. Torres? Mr. Torres here? Okay, we'll have the last speaker. We'll come back to the board for any questions or any directions from the motion.
I'll go ahead and ask some questions, Commissioner Pendergrass, Mr. Chairman. If I may direct my questions to our county attorney's office. So can you just walk me through, for folks who, we do this every first and third Wednesday, so we're pretty familiar with what we're doing here. But for a lot of people, this is the first time they've ever come to zoning. And it seems really tempting to think, well, they have the option to vote no on things, so they should just vote no on things. But a lot of the reasoning that we have to put in behind the decision we make is actually codified in state law, right? Can you just go over, we're not allowed to do things like require people to manage their property certain ways or architectural stuff at zoning. Can you kind of go over the scope of what we're doing here at zoning today and why, kind of how we're required, the constraints that are put on us on how we're required to make our decision?
Yes, sir. The state law and case law on subject matter of zoning cases provides a distinction between your authority as a legislative body and your authority as a quasi-judicial body. In this proceeding, you, as commissioners, serve as a quasi-judicial overseer of your code, for lack of better words. What you're restrained for in these proceedings is to act upon the request based on competent substantial evidence. And the evidence that's presented through the proceeding below, in this case the hearing examiner, is the record evidence that you have before you. You cannot simply deny a rezoning request because you don't like the aesthetics, you don't like the applicant. You must have competent substantial evidence in order to deny it. The fact that in this case you have requests to manage because another area of the county is in a different situation than this, you're precluded from providing conditions or requiring developers to do one thing, in this case arbitrarily, because you don't have the code to do it. As you indicated, you can't provide a requirement that these particular individual properties be managed in a way that similarly situated properties aren't required to be managed. It's a requirement under state law that you apply your code as it is today. Your decision is based on competent substantial evidence, and you provide the applicant with the rights that are required under state law. And it's not a simple thing as counting T-shirts or requesting public support on an item. You are bound by your role as quasi-judicial reviewers of the applicant in application before you.
And what is the hearing examiner in the process? Explain her role.
The hearing examiner is the first hearing after the application has been found sufficient by staff. And the hearing examiner goes through and provides review of the Lee plan and the land development code, and takes the testimony in, determines what's competent substantial evidence, and presents that to you in a recommendation based on the requirements of the Lee plan and the land development code. So the recommendation that you get before serves as sort of the foundation for your review and analysis for the application.
So if we wanted to go against what she's found after taking all the evidence and weighing all the facts of the case and making a decision, we would have to come up with some competent, substantial evidence that we would be able to use to go against her findings?
That's correct. You have to have competent substantial evidence in the record that's presented to you. This is not the proceeding to add more competent substantial that was provided to the hearing examiner. That's not allowed. You were limited to what was provided in the hearing and what's presented today. With regards to these cases, you can't just make new stuff up. But yes, you are correct. If there's competent substantial evidence in the record to base a recommendation, say for lack of compatibility or some other situation under your Lee plan, then you were able to do so. If that does not exist, then you cannot, under state law, deny the request simply because you don't like it.
Okay. Thanks. Thanks very much, Mr. Attorney, and thank you, Mr. Chairman. You know, I'll go ahead and make the motion to approve the hearing examiner's recommendation, and then after I get a second, I'd love to make just some comments.
Good motion.
I gladly will second it, and can I follow up with my?
Yes, please.
Deputy Attorney, what would be the ramifications if we acted in emotion as opposed to facts?
All right, as I would suspect that every attorney that's in this room would tell you, if you were to deny this based on any reason that's not based on competent substantial evidence, the first motion would be presented to the courts for a writ of cert, requiring you to provide the actual competent substantial evidence that you based your decision on. If you cannot do so, then the decision would have to be overturned. In this case, it would be a denial. If you do have competent substantial evidence to support your case, obviously that's the end of that discussion. If the applicant finds that there is no valuable use left of the property and somehow we took those rights from them, which wouldn't be in a case like this, but in hypothetical cases it could be, and then the county would be liable for the damages for that.
So that's fair to say that if we went with emotion and not facts, and we would delay this, incur legal expenses, go through a lot of time ultimately to have this overturned.
That's correct, and then we'd be back in front of you with the decision from the court with the request that you either provide the competent substantial evidence or approve the request.
Thank you.
And added to that, the circuit court across the street has done historically would tell us to approve this and even some add more density based upon the loss of the applicant. Is done in, for example, down in Estero, some cases down there, Estero place, for example.
That would be my number one example of be careful what you wish for. When that case came through, it was denied. We went through an administrative process. That was denied. It went ultimately to the court. The court overruled because we didn't have competent substantial evidence to support that, and the board ultimately ended up approving something much more, or having to approve something that was much more intense than what was originally thought out.
Based upon state law, we can't deny applications based upon the changes of 2011 for transportation, for example, or discriminate based upon the class of people that may live there in the future.
That's right. The state legislature, as Commissioner Mann always says in our hearings, the state legislature helps us out every year. We no longer have transportation concurrency. We can no longer require state permits prior to issuing our approvals, and we now recently can't even require aesthetics anymore. It is something that every year we get new preemptions by state law, and we're here to help you through those.
And we're actually here because of what the state approved about 63 years ago with the urban sprawl potted lots in Cape Coral and Lehigh Acres.
That's correct.
Okay, thank you. Come back to the board. We had a motion and we had was it a second?
There was a second, yes.
Any other discussions?
Just real briefly before we vote, there are some positives from what we're seeing here today that have helped me to agree with what the hearing examiner is recommending. And one thing is we are definitely seeing a reduction in density here, and we are seeing preservation of wetlands, which I think is we always talk about balance when we talk about the future growth of this area. And I absolutely understand the way people feel when you see it right across the street from you. I mean, we've had that, for years. A lot of people have felt that way. So I completely have sympathy for that. We're constrained by the law to make these decisions under the legal qualifications and the rules of competent substantial evidence. So we work to try and make these compatible with the surrounding neighborhoods through the conditions that we are allowed to put on them. And this one, certainly with the reduced density, with the preservation of wetlands and the way it's going to be laid out, actually does look like it has a lot of positives for the community too. So that concludes my comments. Thanks, Mr. Chair.
Thank you, Commissioner Hammond. Any other discussion? Commissioner Sendelli?
Just one other comment. As listening to the comments here and the presentations here, the reality is we are changing, continually as a community, and we have certain demands being placed upon us. And with that, I think we have to continue to look at how we use land, both from a conservation perspective and density and so on and so forth. So this is not a static process. It's a process that's going on every day and it's changing every day.
Thank you. Okay, without any objections to the motion? No objection, motion carries. Thank you. Next case. If I could remind everybody to either silence your phone or turn your phones off, please, during the hearings. Thank you.
And for the third time, Peter Blackwell with the Lee County Zoning Section. This third case, REZ 2021-12, is the third and currently last case for the Meadowbrooks Estates. The request is to rezone 1.52 acres from a single-family residential, RS1, to multifamily, RM8. This consists of lots 1 through 4, Block 71, and lays along North Avenue. The hearing examiner has recommended approval, and according to this was the one with no participants from the public.
Great. Any questions for staff at this time from the board? Being there is no participants or record, we'll come back to the board for
I'll move approval of the hearing examiner's recommendation.
I'll second it.
We have a motion, we have a second. Any objections? No objection, motion carries. Thank you. Next case.
I gave it to Rowan.
Okay.
Commissioners, good morning. My name is Dirk Danley. I'm a senior planner in the Zoning Division of Community Development. This should be your final case today. The request is called Pine Lakes Country Club. It's DCI 2021-00004. The request is to rezone approximately 83 acres from agricultural to mobile home plan development to allow for up to 400 manufactured home uses and accessory uses. The hearing examiner did recommend approval with conditions. There were approximately 35 participants of record. Many of them are here today. Staff and the applicant are here with any questions that you may have.
Thank you. Any questions for staff at this time? Would the applicant wish to address the board? Neil?
Yes, sir.
Come on up.
Good morning. For the record, Neil Montgomery, representing the applicant. You might have noticed that there's about 400 pages of transcript in this case, but the hearing examiner's recommendation is relatively short, and there's a reason for that. There was a lot of testimony on issues not related to the application, and the hearing examiner kindly advised people throughout the proceedings that there were things outside of her scope. So we're here today to determine if there are any mistakes or fact or law in the recommendation of the hearing examiner, and I would submit that there are not. The applicant agrees with the staff and agrees with the hearing examiner. One issue that did come up, and the hearing examiner gave it extensive discussion, and I'm going to ask you to kind of like make a note because you may need to refer to it, and it relates to access. She discusses this on pages 2, 6, and 7, and she has footnotes 5 35 and 39, where she points to the record and identifies the testimony in the record about right of access through the adjacent property. So I'm assuming you'll hear testimony about that today, but based on the record and the evidence, as she has outlined, the only competent substantial evidence regarding the right of access is that the applicant has a right of access, and so she refers you to the pages and information where that can be found. We have the whole consultant team here to address any questions that you might have, and we reserve the right for rebuttal.
Thank you. Any questions for staff at this time?
You're okay with the conditions the hearing examiner laid out?
Yes.
Okay.
Thank you. Thank you. Now, I have questions for our county attorney. So kind of going over what the council said as far as direction of what our role is here is we don't get involved with the, say, HOA issues. We don't get involved. Zoning in this area, we do not dictate. We don't approve gates. We don't approve access. We don't design a community. We don't deny amenities. Our role here is either accepting or denying the hearing examiner's recommendation based upon land use classifications only, not about the color of the building, who's going to live there, the structure itself. We have no role in that, nor are we allowed to, correct?
That's correct. Your role today is the use that's being requested. The items with regards to access and the overall layout of the project will be part of the development order process, which is, as you indicated, outside the scope of your review. But at this point, you have the case, the hearing examiner's recommendation for the use and the change of use that we're looking at today. Not looking at aesthetics or what type of structure is going to be there.
We have no role in that, nor we can make decisions based upon that.
That's correct. And as I indicated in the previous hearing, recently state law has actually made sure you have no role in that by precluding you from making aesthetics types discussions.
In the prior cases here, we have had some cases where we have actually ruled against cases because there was competent substantial evidence based upon the land use, correct? We've had those cases before.
That's correct.
Right. So everybody knows, trying to help you out here, trying to help you out. There's a procedure here. We have to follow the law and follow the procedures. So, okay, thank you. We'll come back to the board. Now we have 35 participants of record. We'll be calling names. And like I said earlier, please keep your comments and any type of applause or anything to yourself as we just want to get through this process and let everybody make sure everybody's heard and heard properly. So the first participant of the record is Jackie Bartolucci. Jackie Bartolucci. Ralph Brooks. Attorney Ralph Brooks. Wayne Brown. Wayne Brown. Is there Wayne Brown here? Robert Brandt. Tony Calvin. I know Tom's here. Tom Clark. Morning, Tom.
Morning. Good morning, Commissioners. My name is Tom Clark, and I'm a long-time resident of Lee County. In fact, in a couple of years, you're liable to be able to call me a cracker. I was for many years elected to the Lee County Soil and Water Conservation District. And the last time I spoke before this board was to enlist your help in eliminating my job because of redundancy and a waste of taxpayer money. There's an old adage that speaking a lie enough makes it become the truth. You are being lied to. ELS would like you to believe that there is already an access via Pine Lakes to the property they want to purchase and develop. It's not a vehicle access, it's a stormwater runoff culvert. When I purchased my house and property in Pine Lakes, I was told it was a complete community with all the amenities. I have since discovered that the amenities are stretched beyond capacity. If allowed to use the existing Pine Lakes to access the proposed property, would adversely affect my lifestyle. I'm not against the development of the property, just the use of accessing it from Pine Lakes Road, Circle Pine Road. My home backs up to Circle Pine Road. Circle Pine Road is used by walkers, bike riders, runners, and dog walkers. It would make the roadway dangerous. The entrance to Pine Lakes is already very busy and dangerous. There has been a fatality at the entrance. Even if there were a traffic light there, it wouldn't help much. Someone was just T-boned at the light at Del Toro yesterday. I beg you to turn this down. Thank you for your time.
Thank you, Tom. Patricia Diniger? Diniger? I can only call participants of record on these cases. I cannot. So who? I'm sorry? I can only call participants of records. If you'd like to wish to address the board, you can address the board now.
I'll be speaking on behalf of some of the representatives.
Okay. Thank you. Ray Dunlop.
Good morning, gentlemen. Thank you. I'm a resident at Pine Lakes, and I own a state property. That is different because I actually own the land that my home sits on. So there's 200 plus homes that are estate properties, and there's 600 and some homes in our property that are leased land. So I hope you understand that there is a difference in the two properties that we have there. I came to the hearing examiner's meeting, and I was allowed to speak that day. But after that meeting was over, I was really disappointed in the way that process went. So I called the Lee County attorney and I talked to him about what happened that day. And what happened was wrong. And what happened was the applicant had legal representation here, and that legal representation cross-examined witnesses in your hearing examiner's meeting. Now, the hearing examiner should be able to ask questions to whoever's here talking, whether it's me or a lawyer or any of the representatives from the applicant, but their legal counsel, it was like it was a civil case and there was only the prosecution was allowed to give their side. I wanted to be over here and say, I represent all these people in the green. I want to
Sir, for the record, you have to be there at the
I wanted to sit in that chair and ask questions to the witnesses, but I wasn't allowed to do that, but they were. So their legal counsel, and if you'll go back and watch the last hour or so of that meeting, she called your staff up, Mr. Danley, and she called up a representative from Kimley Horn and directly asked them questions. But the people who were opposed to that didn't get that same opportunity. The process was flawed that day. So when Mr. Danley came up and they addressed the Lee Code 1.5.1 or whatever the number is, whether or not there's anything possibly detrimental to the existing homeowners, he said no, he didn't find that. And Kelly Klepper from Kimley Horn came up and said that exact same thing, was asked by their attorney under direct questioning, did you find anything? Well, if I'd have been able to sit over there that day and get a chance to ask them questions also, I would have said, well, if it's not detrimental in any way under your expert opinion, is it beneficial? Because the opposite of detrimental, I would think, would be beneficial. I would have asked him, give me an example of how somehow changing this zoning and putting these properties here and attaching it to our existing property could somehow be beneficial. I would have loved to have asked that question that day because I'd have loved to have heard their answer. We're going to have a different kind of housing there than what exists. It's not going to be cul-de-sacs. And I've already heard your explanation is we're not talking about the aesthetics today. But at the end of the day, I wish one of them could have said, give me one example of how it might be beneficial. The way we see it's not going to be beneficial is because it's not going to be cul-de-sacs as it exists.
Thank you, sir. Your time's up. Thank you.
My
The red
time's
light's-
up?
Yes, thank
Okay.
you. Everybody gets, thank you. So everybody understands you get 3 minutes to plead your, you can sit down now, thank you. Everybody gets 3 minutes, there's timers here. When the light turns yellow, you have 30 seconds left. The red, to make it fair, everybody gets the same amount of time. So that's what the little lights are for here, just trying to help you guys out here. So you may want to, actually said, like I said at the beginning of the case, talk about how this could be competent substantial evidence for if you want it denied, provide some competent substantial evidence. It's not about the process today, it's about the case before us today. So thank you. Max Forgy. Is Max here? Max, Rebecca Gloss. Rebecca and Michael Gloss, Gloss. Okay. Must be Michael. Thank you.
Yes, I'm a resident of Pine Lakes Country Club. I live on Pine Lakes Boulevard. And I want to just show you, when you look at that, how they misrepresent this total thing. You notice on that, what you're looking at right there, they don't show the houses. They show it on the next one, but they don't show the houses. The houses is a trailer park. They're 10 feet apart. Not even compatible, anything close. Do you see those 3 roads that they have on there? Those are not there. They put them in there. That's what they want. They want us to believe that that's the only way that you can get out to 41. They haven't even asked the Department of Transportation if they can go on 41 someplace else. When you go to the next picture here, which I don't know how to do, but if you go to the next picture, you're going to show the big holes. They totally misrepresented this to the hearing examiner and really didn't give us. See that little road up there to the top? That has not been approved. There is a road to the left of that, north of that, that goes in and out of the farm. They don't even show that. Also, they don't show any homes in there. You notice that all those blank things? Instead of where the lots are, when they put the lots are, they're so close, you can reach out and touch each they're only 10 feet apart. They're not compatible at all. I'm not opposed to having them do that. What I'm opposed to is those 3 roads that's there. Also, they did not show in the front, along the road, they did not show that there was, in the original plan, a road to go beside the 6th hole there. They totally was just, is a deception to the hearing examiner, and it really wasn't fair. Thank you.
Thank you, sir. Michael Hayes. Michael Hayes. Matt Hare. Beverly, you're speaking for Matt Hare?
I am. Good morning. My name is Beverly Grady with Ratzon Andrus. I am representing Matt Hare and the Pine Lakes Estates Homeowners Association, and also speaking for Beth Thorson. So those are the 2 times she's on your list. There are 263 owners in the Estates Association. They are owners. And access and traffic is the major issue for the Pine Lakes residents being proposed by this rezoning. We request you remand this case to the hearing examiner. Why? We have 2 valid reasons. First of all, the developer wants to access the northerly road, and if you look at that master concept plan for this parcel, immediately to the south is a platted road, Circle Pine Road. They have 3 arrows through 3 access points to the road that's within the Pine Lakes community for its 400 new units. The applicant never revealed the Circle Pines Road is actually dedicated to the Estates Association, and along with the obligation placed on the Estates Association to maintain those roadways. That was not revealed. The official plat for Phase 3 is referenced on page 348 and 349 of the HEX transcript, where the HEX was asking about the plat and had it been reviewed. Instead, the applicant files the Lee County property appraiser sheets claiming that that's the ownership and that they currently maintain. There is today a contract between the Estates Association and the developer to maintain the roadway. That contract has a termination date. The Estates Association, by the plat that dedicates the road to them, also places the obligation of maintenance. Therefore, the Estates Association is very concerned that 400 units are going to be poured onto Circle Pines Road, no condition addressing that, no condition requiring any payment for maintenance. And also, if you look at Plat Book 43, pages 35 to 48, the next phase also dedicates that to the Estates Association with the obligation to maintain. And I have those plats to file here for the record, which were referenced by the hearing examiner, but were not addressed by the applicant in the hearing. And I have then the second, and Dirk, how do I turn this back to get to your first page? All right, so yes, the property outlined in red is the subject property. Circle Pines Road is immediately to the south and leads to US 41. Now, what is equally important is the developer, in this case, led the Hex to believe that the property you see in gray to the north, all the way to the Charlotte County line, Section 5, and the property immediately to the west, Section 7, are owned by the Zemmels Corporation.
Beverly, just for the record, so you're speaking now, this last gentleman, and you're
Yes.
speaking also for the prior speaker?
For Beth Thornton.
So we're gonna ask the staff to redo the clock one more time for you, and as far as that'd be the end of your 3 minutes, then thank you.
Okay, thanks. So as to Section 5, and there is right now an 80-foot access easement along that north property line of the subject property. It services the Diocese of Venice Church and has access onto US 41. The testimony at the hearing was that this developer could not utilize that access. What the developer did not disclose was a deed to all of that property in Section 5 owned by the Zemmels, and Section 7 had already been signed.
Chairman, I have to pose an objection. There's no testimony on the record, and I believe that whatever she's discussing occurred after the hearing was
Well,
closed.
and that's why we want the remand, because this developer now owns that property to the north and the west.
Ask you one
Yes.
time, please stick with the record, and as I said earlier, we're not voting on the amenities of this location. I'm just trying to help you out here, but stick to what was testified at the record, or else I'm gonna have to ask you to sit down, please.
Okay, so what I'm saying to the board, if the deed was recorded on December 8th, 6 days after the hearing, so the hearing examiner did not know,
The record is not allowed under your procedure.
then I will proffer that, and we will raise due process arguments, because the developer has other alternatives, and the board needs to know. And I know Ms. Montgomery doesn't want me to share this with you, and I'm not asking you to decide on that today, but I am saying this is when you do remand, when you find out developer actually has other transportation alternatives, back to the hearing examiner, so that the hearing examiner can address that, and then you're fully informed. That's what I'm asking for the remand, not for a decision, but for a remand, so that you can look at what developer owns hundreds of acres along US 41 and has many alternatives for access, not putting those units through Pine Lakes community. So we would request that you remand so we could present that. I will offer this and file this with the clerk, and I have copies for the board if you would want to see the deed to this developer that was signed in October before the hearing examiner, but not recorded till after.
You can give it to our county attorney that will
Yes,
do that for
certainly
the
will.
record to see if it's part of the original hearing, because again, we're voting and overseeing the original hearing recommendations from this case. And if the county attorney wants to add something to the record, a file, it's up to him.
Beverly, what's this stuff?
I'm sorry?
What's this?
Oh, the pages are actually from the applicant's Exhibit 1 to the hearing examiner to show the location of the property. I was able to use Dirk's exhibit he had on the screen to make those points. These are, first 3 pages are all from applicant's Exhibit 1 at the hearing examiner, again, showing Cape Coral is to the north and the west, but not disclosing their ownership. And the last section is the plat. Shows Circle Pines Road, shows the dedication highlighted where it's dedicated to my client, the Estates Association, for maintenance as well as use.
Beverly, to be clear, this was part of the record already?
Yes, yes, that's applicant's Exhibit 1 at the hearing examiner, and the plat is referenced by the hearing examiner and by Matt Heyer in the transcript.
This is the
deed is,
instrument number?
yes, the deed did not come to light until it was recorded December 8th, 6 days after the hearing. But you'll see it was dated October 8th, almost 2 months before the hearing examiner hearing, conveying this property to the same developer.
Thank you. I have another speaker, Jan Hippler.
Thank you.
Dan Hippler. Pamela Johnson. Pamela Johnson.
Excuse me. Morning. Thank you for allowing me to speak. As a resident of Pine Lakes, we live there for the security we have. And on the map that's been proposed to you and on current record, they do state that there's an access point. The access point clearly is, as mentioned before, a drainage point. There is no motorized vehicle access. It would have to be developed for a road. And the additional roads that they would be putting into this community would cause access after you rezone it and they build and develop the roads. That diminishes our security and our safety. This is a gated community. It's fenced all the way around. And by opening access to it, rezoning next door and giving them access to that road into our community diminishes our security, our culture, our lifestyle, our health, by additional people that will be in that area that are not checked at our gate, that are not security vouched for, and will have all kinds of possible crime and damage and whatever. But I'm not opposed to the development, but I am opposed to them developing and rezoning it and allowing them access to us, unless they can prove that that access point is actually a place where people can get through, and it, other than with motorized vehicles. If not, then I'm just asking you not to approve it based on our security, our lifestyle, and what health concerns and safety concerns it might present to us.
Thank you.
Thank you.
Pamela Johnson? That was me. Oh, there we are, Pamela. Okay, sorry. Pam Crone. Pam Crone, K-R-O-H-N. Robert Quintenzi. Robert Quintenzi. Okay.
Good morning. My name is Robert Knetsny. At the recent HEX hearing, it was ruled that there is no connection between Chapter 723, the Florida Mobile Home Act, and this specific rezoning request. So any discussion pertaining to Chapter 723 was deemed out of scope. The ELS attorney made this very clear to the Madam Hearing Examiner, as she did not want the Madam Examiner to hear what our attorney intended to say and present. It is interesting how two different attorneys can have two different points of view in this subject. I would like to inform you that it is the opinion of the Pine Lakes residents, as well as our attorney, that contrary to ELS legal opinion, Chapter 723 and the specific code violations which have occurred were the direct result of not only this request for rezoning, but also the request for the 3 ingress-egress roads into Pine Lakes from the French family farmland. You see, Chapter 723 was created by the Florida State Legislature because they recognized that mobile home owners have basic property and other rights which must be protected. Based on this premise, how could Chapter 723 and the current violations due to this rezoning request not be in scope of this decision? Section 723-012, Section 13, specifically states, a statement of the nature and type of zoning under which the mobile park owner operates, the name of the zoning authority, which has jurisdiction over the land comprising the mobile home park, and if applicable, a detailed description of any definite future plans which the park owner has for changes in the use of the land comprising the mobile home park. Hence, under this statute, Chapter 723 is relevant. It is the opinion of the Pine Lakes residents that due to this rezoning request, ELS has violated codes within Chapter 723, specifically 723.003, .011, .012, .014, .016, .017, and .021. It is no wonder that ELS proposes that Chapter 723 is out of scope. We are requesting that this decision to rezone the French family farm be referred until further investigation is given to this issue, as well as the issue of road ownership and the 3 proposed access roads, and the issue of significant impact to density and intensity to our community.
Thank you. Your time's up. Thank you. Mario J. Magnetti? Mario Magnetti?
Mr. Chairman, can I ask before you go to the next witness, you just heard a person say that Chapter 723 is something you can deal with. I'd ask you at some point in time in the proceedings to ask your attorney whether or not there's a state preemption.
Thank you. And that was 723? Thank you. Mario, not here? Okay. John McDonald? John McDonald? Kristen Mellott, M-E-L-L-O-T-T?
Good morning. I'm Kristen Millott. I'm Pine Lakes resident. I get no say because I'm a leased land. So my purpose for being here is to let you know that I have followed this process from the beginning. No one has listened to my observations of the fact that that property floods. There was nothing was addressed regarding the flooding, regarding the stream bed, and other points on that property. I've never seen anything in writing regarding that. I'm concerned with the future of the county, of putting places in there that the county will again have to step in and put money towards rescuing people that have brought properties there and have no place to go when their places are flooded. And I'm concerned with the number of people that they're putting there and the services that are required for those people. I am not against rezoning. I'm against this particular rezoning. Thank you.
Thank you. Thomas Menahay? Menahay? Sir, I'm calling you to speak now. I'm not going to call the attorney at this time. Would you like to address the board, yes or no? No. Thank you. Gary Nicolio? My Italian's off a little bit this morning. Nicolio.
Nicolini.
Come on down, Gary.
I can help you out there.
That's fine. Everybody swoops it up.
My vice chairman here, help me out here. Commissioner
My name is Gary Nicolini, and I'm also on the HOA 2 board as one of the directors. Just real quick, you see all these people here today, okay, represented with green. There's a reason for that. We are definitely opposed not only to the addition, but to the roads that they want to use. You can't tell me that there isn't a way to get access in and out for that development on 241, especially hearing that they bought property north and I believe, west of us. So we're not going to go through this again with these other properties that they want to come through Pine Lakes to have access to 41. Definitely opposed to it, and I'm asking you not to approve it. Thank you.
Thank you. And I'm sure sometime later today you will hear us ask staff some questions about this, but again, we do not approve roads that's through development stages, and the state road that's going to be done to the State Department of Transportation. So Charles Orbeck. Charles Ringlinger. Charles Ringlinger. Okay, come on down, Charles.
Good morning.
Morning.
From listening to the meeting so far, you guys are basically a rubber stamp for the HEX meeting. Is that correct?
So we don't take questions from the dice, but you please have time. There's your 3 minutes to speak to us about competent, substantial evidence about.
No, I'm not talking about your competence. I'm just saying you're basically a rubber stamp. That meeting has already been brought up that it wasn't conducted properly. I don't think it was. This woman here interrupts all the time. She interrupted day after hour of that meeting. And I think you should send it back and maybe have that meeting all over again, asking her not to interrupt people where they lost their train of thought. Thank you.
Thank you. Richard Saniti, S-A-N-I-T-I.
Come on up.
After that, Johnny Stanley.
Good morning, gentlemen. Thanks for listening to me. I'm a estate owner in Pine Lakes. Been living there a while. I just wanted to express my concerns over to the 3 access points that are going to be going on Circle Pine Road. I'm concerned about the safety of all the residents that, as you heard before, walk up and down that street constantly, morning, afternoon, evening. It's a highly traveled road, and having 3 more access points where you possibly can put as many as 600 or I guess 300 vehicles entering the Pine Lakes community would probably not be a good idea. And I just wanted to express the safety concerns that I have for all the residents in Pine Lakes. Thank you.
Thank you. Johnny Stanley. Johnny Stanley. Ron Thorson.
Thank you, Commissioners. I decided to go old-fashioned route. In the HEX hearing, I had a PowerPoint presentation of 300 some odd slides. It's probably in your record, and you see it. I did it by hard copy. These are just official records of what we're going to talk about here for my brief time. My name is Ron Thorson. I am a director on the HOA2 board in Pine Lakes. I'm a full-time resident in the state of Florida. I'm a voter. So are these people. What has happened through this whole hearing, and we got to go back to something really, is that in your first insufficiency letter from your staff, it talks about ordinance or resolution ZAB 8597. That hasn't been answered because in order to change that, according to what we've been explained, it requires out of your LDC 34201, 75% of the property owners. ELS does not have 75% property owners, so you're going to make a change into this, and ELS only has 603 lots. There's 866 lots. One will say 67. The numbers, I believe, is 866. 75% of that is 650, and they only have 603. So they're making changes to this, and of course, that hasn't happened. It went through 3 of your insufficiency notices. By the way, I sat as a 3-term city councilor in Superior, Wisconsin. I've been on your side of the fence, and I understand about the people. But they're the ones that put the roads in under this whole thing. The only group that could do that. No other property developer could ask to have access to that. So it's very important to look into the attorney's question of whether or not who owns them, who has access, and so forth. And we weren't allowed to do any of that. And by the way, Mr. Ray Dunlap, who was up here before talking about being interrupted, I actually asked Madam Hearing Examiner to be able to speak, and they kept interrupting me during that time as well. So all this that has happened hasn't addressed the ordinance that, or the resolution that a body such as yours before approved, and it says when complete, there's 866 homes on 362.6 acres. And by the way, during that hearing, I'd had a map. They've put in an ad resolution. You should be aware of that because that's part of your study, to actually have a minor change to a lot of these roads. And I tried to get the map and a blueprint, And they had altered the blueprint, took all the language out about the frontage road. The frontage road all described, there's a sign out there, how it would be disposed of, who would pay for it. If that frontage road ever went, which doesn't enter into or out of the Pine Lakes community, it runs along Highway 41. It wasn't even able to be addressed. I've been told there are different rules and so forth, but all of these things they've controlled because they entered these 3 roads into this formula, and they're the only ones that could do that. Thank you.
Thank you. Next speaker is Frank Tevna, and Mary Tevna after that.
Am I allowed to?
Good morning. My name is Frank Tibnan. I'm a full-time resident of Florida and of Pine Lakes. Thank you for the opportunity to speak. No one doubts that a large corporation can dot the I's and cross the T's to meet legal requirements. That is a strict and narrow interpretation of the law. We're asking the Board of Commissioners to consider also the human and moral impact of this development. We are the flesh and blood victims of this development, and victims we are. We do feel betrayed. When we purchased our land and homes from ELS years ago, we purchased it because of what our eyes told us. We knew the number of residential sites, the scope of the amenities, and we knew the ratio between homeowners and amenities was reasonable. Put yourself in our shoes. You know Cape Coral has a lot of streets with a lot of vacant land. What if you built a home on one of those streets? I'm sorry, not built it, purchased it. And you purchased it because partly it had a swimming pool and a tennis court, very attractive. And then years later, the government says to you, you have new neighbors moving in, therefore you must share your swimming pool and tennis court with them, whether you like it or not. That's what's happening to us. That's why we feel betrayed. Our lifestyle that we purchased is being severely compromised. This new development will bring in roughly 700 new residents. They will be able to use some of our amenities. That's not fair. It's like squeezing a size 10 foot into an 8 size shoe. And we're going to pay the price of that. Gentlemen, there is a solution. If ELS gets this French property, they will own 4 consecutive developments in a row. Lake Fairways, Sunseekers, Pine Lakes, and now this French property. That's a huge profit from that landscape. The solution is simply ask them, build fewer homes, build more amenities, take a little less profit, but that way everyone will be satisfied and there will be no more objection. That is the only honest and fair way to handle this. Thank you.
Thank you. Mary, would you like to address the board too? After Mary, we have Charles Wakefield.
Good morning, gentlemen. My name is Mary Tivnan. I am a Pine Lakes homeowner, estate land. I've loved living there, and I'm one of those who likes to walk her dog in the morning on Circle Pine. I see joggers, walkers, people on bikes, people in the golf carts. We have a 20-mile-an-hour speed limit, and most people adhere to that. A few don't. Case in point was we have a woman in our community who is blind. She has a service dog, thank God, because one morning when she was taking her dog, Charlie, for a walk, one of these people who are supposed to adhere to the travel, you know, the 20-mile-an-hour thing, almost killed her because she had, the service dog, thank God, pushed her into the dirt. She was not really on the road so much, she was kind of on the edge, but if the dog hadn't been there, that woman probably would have been killed. I mean, the dog saved her life. It's the kind of thing that makes me really upset that they want to put in more roads into our Circle Pine. The traffic will be unbearable. I kind of forgot that there might be 600 or 700 more cars there coming into these 3 roads. That horrifies me. That's one issue I have, and it's a big one, and I'm very upset over it, obviously. The other issue, though, is when you drive down 41, either from the north or you're trying to come from the south and enter the guard shack into Pine Lakes. Now, sometimes it's not too bad, but I was there one day, I was 6th in line. And the reason was the first person had to check in with the guard person. And, you know, had to give a name and all the stuff. It's pretty secure there. And it took a while, which meant the person behind me was sticking out on 41. And the cars are coming like crazy down 41. I was scared to death for that person. Not too happy for myself either. I mean, the traffic is unbelievable. I know that there were traffic surveys done, however, they were done in off, you know, snow, what do you call it, snowbird time, whatever. The traffic now is pretty bad. It will lighten, but if we get 400 or 500 homes in the French property, I don't know how we're going to get through that. We already have a fatality. We had one out front sometime this past year. And there's a little memorial out there which the relatives and friends often will decorate. It's very sad. It could happen to any one of us. Thank you for listening.
And hopefully speedy recovery to your neighbor with the dog, so be safe out there. Thank you.
I didn't hear what you said, sir.
I said, hopefully your speedy recovery to your neighbor that got hit by the car.
I
so,
know.
Okay. Thank you.
Well, that person died. The one that got hit died.
Oh, she did, okay.
Yes, thank you.
Charles Wakefield, please.
Charles Wakefield, I'd like to pass my time on to our attorney.
She already spoke, so would you like to address the board now? Yes or no? No? Okay, thank you. Pamela Wagner. Pamela Wagner. Betty White. That's her name, Betty White.
It's been entertaining.
Oh, Betty White, okay. Bruce Word, W-R-E-D-E. Bruce? Okay. Bruce with the phone, I recognized you. It's all right, Bruce. It always happens. It happens to us too sometimes.
It was my doctor, so.
That's important then. Thank you.
Gentlemen, hello. My name is Bruce Reed. I'm a member of the Pine Lakes Leaseland Board of Directors. Just one thing I'd like to clarify. In the HEX hearing, the HEX officer put down a footnote that there was testimony given by residents of Pine Lakes that they do not oppose the rezoning. During the HEX hearing, I was the president of the HOA too, and we hired 3 legal experts to definitely oppose the rezoning of that property, basically based on the fact that when we were sold our houses, we were sold a lifestyle. If this development goes through, that lifestyle that was given to us through our prospectus and through our leases goes right out the window. We will no longer have the ability to use the amenities that we were given, nor will we be able to get around inside the community like we thought when we bought the property. A second point I have is, and does that thing work?
Use it? I do.
I thought I had my diagram. I'm sorry.
You're okay with it being displayed?
Was this presented at the hearing?
It's a diagram of the proposed roadway through the property. You see that little yellow spot there?
Yeah, was this presented at the hearing?
The roadways were presented at the hearing, yeah.
Or was this?
I don't know if that particular diagram was presented. I don't have another diagram. But if you pull up the, if you can pull up the diagram, that was, I'll have to pull up the diagram if you don't want to let me use this. That's fine. That's fine. We can use another diagram.
You got other maps in there.
Okay.
Does that help you?
Yes, thank you very much.
Okay, thank you.
As you can see here, the one diagram all the way over to the well, will be our right at this point, is the roadway that the ELS says that they own. And based on the ownership of that roadway, they filed for the add 2-021-00147. My contention is that ELS does not own that roadway, the county owns that roadway. If you look at the application for final approval of development order dated December 19th, 1985, part of that development order is, there is a amendment or attachment A, which states based on the latitude and longitude, the location of that road. Now, the location of that road has never been verified other than the fact that it's stated in the original documentation. If you go through that order, you will find a indenture notice from Pine Lakes Venture Florida Partnership with Lee County, a political division, selling a piece of property to Lee County for the sum of $10. That certain parcel is described in Exhibit A, which is the roadway, is hereby referenced as part of. This is a deed to the property to the County of Lee for that roadway. In addition, part of the agreement here is that the owner shall agree that such time as the county engineers determine that access roads should be constructed and serve the property north and south, they have 90 days to build that road. So far, the county has not given them permission to build that road, so how can they even own it? Another point, at the public hearing that was held, ELS admitted that they only own the road up to the property line. They do not own any of the road in the French property.
Bruce, I gave you some extra time because we had some discussion here about your documents, but your time's up though, so thank you for your.
Oh, I'm sorry.
Thank you. It's okay, I'm just trying to let you get your point across, but again, we don't see the roads doing this stage, right?
Lee County owns the road and ELS does not. And that should be looked into before this is approved. Thank you.
That's something that the board does not review that though. Bonnie Wright, W-R-R-I-G-H-T, Bonnie. Next speaker is Jacqueline Yamboski. Jacqueline. Okay, that's the last participant of the record. We'll come back with the applicant wish to address the board.
Yes, sir. Let's start, if we can, with this graphic, because I think Frank told you that if this project had amenities, he'd be all for it. I'd refer you to the A in the middle of this site plan, and then if you look to your left, you see that A is amenities. So you've heard a lot of discussion about amenities, and they want this development to have amenities. I just wanted you to be aware of the fact that it does, in fact, have amenities, and that they would have, as you can see, access to those amenities. I would also note, several people said that I objected. I did object throughout the hearing, and you can see that when you read the transcript. I objected because I was trying to keep the transcript and the record about this property, this application, and these proceedings. And as you've noticed today, you've had some testimony about the adjacent property, about other provisions, but not about this application. And in every instance, maybe except one, the hearing examiner agreed that we were diverging from this application and this property. So I will acknowledge that I did object in an effort to try to keep the record clean. And I would also note that under your administrative code, the hearing examiner is not allowed. You haven't given them the authority to go beyond what you have in the four corners of your LDC and your administrative code. So they're not allowed to consider things outside the scope of the application. You've heard a lot of discussion about Circle Pine Road, so I go back to where we started, and I said that on the 3 pages that I mentioned, I think it's 2, 6, and 7, and the footnotes in those, that the hearing examiner reviewed the competent substantial evidence and that they found that ELS does own the road. I appreciate the plat that Ms. Grady pointed to, and it does in fact give the residents the right to use the road. It doesn't give them ownership, it gives them the right to use it. As you might expect, that they would have the right to use roads within their communities. And I don't think that is that issue. I know someone discussed stormwater. We have the engineer here if you want to hear testimony on stormwater, but there was extensive testimony about historic flows. Mallory Clancy has been on the site several times, examined the existing system, examined the existing conditions, and examined some of the existing permits, and provided testimony that this would not have an adverse impact on the residents. In fact, potentially because of the retention pond would improve the situation.
Thank you. Excuse me, point of order. We control the time as far as this. The applicant has open time to respond back to the board, so thank you. This is the process. Would the board like to hear any discussion from the staff about the flooding and what happens to the development stages as far as the flooding and water mitigation? Any board has any questions for that staff? No?
I mean, Mr. Chairman, if I may, the reality is on the flooding issue, clearly you can see from this diagram here, there's stormwater treatment, and there will be retention ponds and things like that that will address the flooding. So I'm okay with what I read in the record as far as the flooding question is concerned. I do have some that I'll ask later, but typically we do, it's part of our code and hearing process, allow for the rebuttal time for the applicant. So I'm interested to hear that.
Okay. Would you like anything else to add?
Pardon me?
Like to add anything else, Neil?
Well, and then I wanted you to see the area, the environmental area. I know that one lady was concerned about, you know, any species that might be there. That area, as you can see, is going to be protected, and it has to go through the ERP process. So, and then there was discussion. I think you heard somebody talk about 75% in ownership. I just want to make it very clear, the entire property known as the French property is under the ownership of the applicant, and the authorizations were reviewed by the staff. This issue was raised at the hearing examiner, and again, proper authorization for this property has been included, and some of that testimony was in regard to a separate application that's not before you today. You heard I think the last gentleman talk about that the county owns the road. Some of you may remember, maybe not, there was a period of time when the county required the dedication of a 40-foot access road parallel to an arterial. It was created under Mike Carroll when he was the county engineer. The county did that for a while. They got sued, and the county did not prevail in that litigation, and the county stopped asking for the 40-foot parallel road dedication. There were some people who actually moved forward under that requirement before it was invalidated, and that deed is for the 40-foot access road during the time frame when it was still in the books. So that's what that property is. It's not Circle Pine Road. The traffic engineers here, if you want to have questions about access to 41, I would say that, as you know, it's a state road, and this property is limited to the one access point through the FDOT permitting process. It would not meet the spacing to provide 2 access points on 41, so that will not be provided. Do you have any, if you have any other questions?
You said there was not access provided to this new area, 240 from FDOT?
The city property?
Yes.
The city property is not before us. There's no permitting. As best as I know, no zoning is outside the scope of these proceedings. And I believe the cross-access easement that was submitted referenced the names demo in there several times. And so any use of that has to be, as I understand, with the permission and consent to the demos, which I don't believe they have at this point. So And that's outside these proceedings. We didn't provide, we just provided testimony that we did not have a right to use it. If you want the owner to provide that testimony again or reiterate that, we can.
Anybody have any questions for the applicant at this time before we go to county staff or county attorney for questions?
I did want to ask some about traffic.
Yes.
You mentioned you do have your traffic expert here.
Yes, we do.
Could you come to the podium real quick? So, so you're a traffic expert, great. In your experience, the people who will move into the newly planned part, what do you expect, what traffic pattern do you expect them to use mostly then? Will they be exiting out onto 41 and entering from 41? Or do you, in your experience, see people drive 20 miles an hour through an existing community to get to their homes?
Right, and for the record, Addie Clark, I'm a professional engineer in the state of Florida, and you're exactly right. Usually people take the path of least resistance to get to where they're going, their destination. We were seeing that the majority of traffic would come from the south, just for the layout of the county and different origins and destinations there. But we were seeing that if the access to the north is approved by FDOT in the development order process, that would be an attractive access since it does provide direct access to that location.
The other question I have is if it is designed this way, is there anything that would prohibit people who live in the southern community from using those accesses to drive through the new part to go out on the new access to 41?
I don't believe so. I believe with the interconnection, and definitely look to ELS to answer that there would be allowed to have that interconnection and that shared access along Circle Pine Road. Is that your question? Did that answer?
Yeah, I mean, I guess I know traffic can go all different ways. So if for some reason the Pine Lakes access at 41 that exists today were blocked because of an accident or something horrible, would people be able to go out the other access to the north then and still be able to leave their community if they needed to?
And so that's one of the reasons, one of the many reasons why the code LDC section 10-291 requires more than one access point for issues like safety. If there isn't something going on at the one access point, there is another way for traffic, emergency vehicles to get in and out of the location properly.
Okay, thanks.
So I have a question. Please, I need you to keep the comments down, please. We're conducting a hearing, please. So my question is, so if there was no access allowed though, by FDOT to 41, what access points would they be able to get to their residences?
So there would be.
You're dependent. You said if it's not approved, what would they do then with the new units?
Sure. So usually an emergency access would be something that we would also request if DOT did not allow true vehicular public access using that road. We would then likely request emergency access only, so something that would be closed off from passenger vehicles like you and I, but would be able to access by, say, an ambulance or fire truck. So we see that often where you see maybe a dirt driveway and it's blocked off for ambulances or emergency vehicles to come in and out.
So when referring to if the units were approved and the FDOT said 3 months from now doing development said you're not going to have access to 41 from that portion of the road, what access point would you use to get to 41?
The existing access at Pine Lakes Boulevard.
Which is through the community now, the current existing community.
Correct, and then the three interconnects that you see on the plan above.
Have you had any discussions already with FDOT as far as the right in, right out, or left out from this current position of the road?
Yes, we have had verbal discussions with FDOT. At this point in the zoning process, we are not technically required to have approval by the Florida Department of Transportation, but we have had conversations knowing that the residents had concerns, and so we have had multiple conversations with them, and of course we'll be continuing and having to go through their entire permitting process, do another analysis, look into safety and operations very closely during that process.
How close is that new entrance be to the existing? How far away from it? How many feet is it? Quarter mile? Do you have it down by feet?
I believe that would be about 600 feet to the south. Yep,
The current one?
I believe so. I would have to double check. I believe it's around 600-ish.
Just looking at the scale here, it looks like there's a big lake there, so a couple of golf holes is probably a couple hundred yards, so it's probably at least 600 feet.
Yes, and I just got confirmation about 639 feet.
I know the county code requires at least 600 feet spacing before the new entrances, so I'm not sure what the FDOT's code is for that.
Correct. It is similar, and but I believe that was one of the deviations requested through the county, and that would be something that we would go through with DOT, knowing that that would be a non-conforming spacing per FDOT's requirements as well.
Great, thank you.
Thank you.
Any other questions for the traffic engineer?
Thank you.
Thank you.
I would note that, you heard a lot of discussion about compatibility. The hearing examiner specifically addressed compatibility and said compatibility doesn't mean it has to look exactly like your neighbors, but it has to be consistent with, the land use pattern and densities in the area. And she made a specific finding, and she addressed the concern you heard here today specifically and found that it was compatible. If you need testimony on that, Kelly Klepper is here, the expert planner, and can further address that if you need it.
Okay, thank you. Any questions for the board at this time? No, sir, we already have public comment. Thank you, though. I have a couple of questions for the county attorney. Michael, can you talk about the process? I know a few of the people spoke about the process that this went through, the hearing examiner's process, which we never ever actually participated in, so we don't see that process. Can you tell me if it's legal and sufficient, everything was advertised, the process, the way it was laid out by the HEC's recommendations? Can you give us a little overview of how that happened, how that occurred here in Lee County and other counties when you have this type of hearing?
Yes, sir. The comments that you heard this morning about the process and the ability to cross-examine witnesses, state law is very clear on this matter that public participants are not entitled to cross-examine witnesses. The only parties that can cross-examine witnesses would be the county or the applicant. That's just, it's straight state law. It's not an actual flaw in our process. The members of the public are offered the ability to ask their questions, and then those questions are addressed by the hearing examiner and the applicants. That's how it's done. There's nothing illegal or inconsistent with state law in that process.
So the process is went through was legal and sufficient based upon under state law as far as the cross-examining of the witnesses and the staff, as far as the applicants and our county attorneys, correct?
That's correct. Our administrative code was amended years back to be consistent with state law, and it is, this hearing and the preceding hearings were consistent with that.
And the current existing community, Pine Lakes Country Club, went through the same process years ago too. Does anybody know how long it's been there for?
I do not.
So it went through the same process too?
If it was approved as a plan development, it would have been through the same process.
Thank you. Any comments from the board?
I do have some questions for our attorney. And, I'm sorry, Michael, these probably aren't I'm going to ask you the questions, whether they're yours to answer or not. Here's my question. Clearly you can feel the sense of anger from the residents and the people who live in the existing community, right? They're mad. They don't understand the process. Again, this is something that is really frustrating, I think, for a lot of the residents. Looking at the record, it says residents testified, and we saw them again do it here today, on matters related to overburdening amenities, prospectus disclosure requirements, mobile home park expansion concerns, homeowner consent, lot rent assessments. All of these concerns are outside of the scope of our LDC review guidelines. And furthermore, these matters are statutorily preempted by state law, meaning we're not allowed to rule on those matters by state law. So what recourse do people have?
From the standpoint of the 723 analysis, and I read the hearing examiner's recommendation and transcripts as well with regards to 723, that is outside the scope of these proceedings, regardless of whether it was preemption or not. The statute is set up in a manner to provide rights to tenants and people who own property within these types of developments. It is a civil issue. If the prospectus is changed in a way that is material to these individuals, they have the rights to go through the process set out for state law or some other civil action. That is not something that we get into. As far as the preemption goes, reading the testimony and hearing the discussion this morning, it appears as though some individuals want the county to deny the application because of the statute and what they perceive as violations of the statute. The very point of the preemption is to preclude us from approving or denying these things based on the statute. This is something that's outside of your scope, and it's not something we would recommend you legally doing. As I indicated, they have potential action under those provisions that they reference, and that's between them, their attorneys, and the current property owner.
So if I'm hearing you right, you're saying their recourse is through the civil courts and their attorneys?
There's a whole series of statutes as to what needs to be complied with. If that has not been complied with, and that has some relevant legal ramifications, then they can go through whatever civil proceedings they can.
Okay, and then so, obviously we get sued in civil court too. We get sued in court when we make the wrong decisions that are illegal at zoning. And when we do lose those, we usually end up having to pay a lot of taxpayers' money. And on top of that, the builder gets to build whatever they wanted, usually more. So that's not a good outcome for anybody.
It's not.
So if we were to approve the hearing examiner's legally approved, or the hearing examiner's recommendation, if we were to, that's her recommendation based on the legal standard, the competent substantial evidence that she collected. If we were to approve that, that doesn't preclude them from following their civil action that they want to.
That is correct.
So they could continue to do that regardless of what happens today then?
That's correct.
Okay. I think that answers my questions.
Michael, I have a question real quick. Thank you, Commissioner Hammond. Is there anything we saw or you heard today, based upon the prior testimony today, that is any reason to remand this case for any reason, based upon lack of evidence presented to us as far as the recommendations of the rezone of the 83 acres from agriculture to mobile home plan development?
The hearing examiner reviewed the testimony at length. As y'all are aware, the hearing examiner process provides for applicants and members of the public to speak on the matters ad nauseum to some degree. That testimony was presented. The hearing examiner, based on the competent substantial evidence, did not find either that the testimony was relevant or that the testimony was sufficient to deny the application. There was nothing presented here today, with the exception of one item that wasn't already presented to the hearing examiner, and the hearing examiner recommendation found that that information was not competent substantial evidence to support a denial. The one item that was presented that was new, which was regards to the purchase or the adjacent property, Ms. Grady provided this instrument number. I'm not going to read it, but she provided it. Your administrative code and your land development code permits the participant to provide evidence that was not available at the time of the hearing. In this case, this was not recorded until December 8th. Beverly, am I correct? My eyesight's going bad. December 8th, after the hearing. So from that standpoint, it is sufficient for you to accept that. However, the fact that the property was purchased and the property is adjacent to it does not change the application that was presented to you. Remanding this case to the hearing examiner to consider alternatives that are not part of the application is not appropriate. If the applicant were to offer that, then obviously you could remand it for that purpose for further hearing. That's not before you today, and that is not a sufficient basis to merely owning property nearby as a reason to remand.
Thank you. Any other questions?
So,
Mr. White?
just to reiterate, Michael, just so I've listened to everything of everyone that spoke today. Chapter 723, disregard. 3 ingress, egress, disregard. Do not oppose zoning. They said, for the record, they didn't oppose the zoning. I mean, that's obviously an issue that was raised. And the last was obviously the purchase property that you referred to. Are any of those conditions that were mentioned here today reasons for us to remand?
No, sir.
Okay. Thank you.
Thank you. Any other questions, comments, motions?
Interesting. My concern, when you distill almost anything that we do comes down to a public safety issue. And when I look at this, if I look at the piece that would go out to 41, it seems to mitigate, one, it seems to be a better situation from an ingress-egress and for a safety issue. I can't tell you I'm smart enough to figure out if that was just within the scope of what we can look at today, but it would seem that that would satisfy, in part, you know, from a safety issue and from an ingress-egress point. But you're going to have to help me with if that can even be part of a consideration.
Is that a question for the county attorney?
Yeah.
Which part?
Can this parcel, the piece, the little jog that goes out to 71, can that be made a part of this?
I'm not seeing.
It shows on here, but I'm not sure I'm comfortable that that in fact would happen.
So you're asking, can we condition our approval today based on them gaining access to US 41?
Yes, on the northern section.
Michael, what's your thought on that?
You're the attorney. I'm trying to figure this out here.
Yes, sir. Would the suggestion be that in the event that the, I guess it looks like a little tail,
right,
access, the right in, right out is not approved? I think at this point, we would have to have further testimony as to the impacts of that not happening. I cannot opine as to the transportation impacts to that. The testimony that you just heard from the transportation expert was that if that's not approved, then the access points, the 3 access points would serve to provide access to the southern piece. I'm not sure, and I haven't seen whether testimony was presented to the hearing examiner that showed that that access point didn't exist, what the impacts would be. So I cannot opine on that. If that's a concern, then at that point, I would suggest that a remand in light of the potential of that not being approved would be something that would have to be go back to the hearing examiner for testimony on. If that was part of the discussion and the applicant and staff can jump in at that point and say, yes, it was, and here's how it was discussed and addressed, then it's part of the record and it wouldn't be appropriate to remand it. But if it hasn't been, and that is a concern, then at that point I would recommend you remand it to the hearing examiner with the limited function of that hearing being to discuss if that access is not approved, would her recommendation remain?
I agree with Commissioner.
Well, that's why I asked the question.
Okay.
So, Michael, wasn't going to directly ask that, but when I was asking about remand of the total project, but that one interest is that could be, based upon the 2011 state law as far as transportation, how does that affect that ruling based upon the 2011 state rulings, based upon his question?
Well, based upon Commissioner Sanders' question, he was proposing a hypothetical that I don't have the background to tell you. As Neil was indicating, she's standing there now. If that access point is not permitted, they would have to modify the site plan, which would require them to go back through the public hearing process. With regards to the traffic concurrency issues for 2011, that's not an issue before the board. However, site plan and traffic circulation through other residential areas is something that's within your purview to review, and regardless of the 2011 change in law.
So a follow-up. So if what I'm hearing is there's a condition to actually have this approved, that's one way to obviously come to a conclusion, that is addressing Commissioner Sandelli's safety. The other is to remand this for safety until that is that issue has actually been decided.
Correct. If your concern is that if the access point is not provided, then as the code, and I want staff to confirm that the code will require you to come back through a public hearing. Alternatively, if you want to propose a condition that if that access point is not approved, that it must go back through a public hearing process, that is appropriate for you to do.
So what you're saying, you could be a motion for approval based upon the approval from the FDOT for access to the new property.
Well, I would say
Without that, though, it would come back to another hearing.
the testimony is, and that what I'm hearing is the motion would be recommend approval of the hearing examiner's recommendation with the additional condition that in the event that the right in, right out is not approved at that, whatever direction that is, east, that the applicant must come back through a public hearing process to amend the site plan.
Make that motion.
So your motion is to approve based upon the recommendation and approval of the FDOT access, okay?
I would second that.
We have a motion, we have a second. I have a quick question for that. You said site plan, would that change the density and without the approval of that, when it comes back to a public hearing, could that affect the site plan based upon the amount of units from the original request?
No, I don't see based on this site plan that changing. What you would see is the little tail going away and then assuming it wasn't done, the reanalysis of the circulation of the traffic in light of the fact that it wouldn't be able to go out on 41.
Okay, thank you.
Well,
Any other discussions for the motion? I think the motion obviously takes consideration somebody's safety concerns and access, and as far as people driving through the community that doesn't live there, so. Any other comments? Any objections to the motion? No objection, motion carries. Thank you. We are adjourned.